Hi there, contract student, and welcome back to our third lesson in this sequence on contract interpretation. If you want to follow along at home with notes, illustrations, and examples, you can get a copy of my contract interpretation slide book at the link below. Today we're on slides 84 to 101 for those who have a copy. Also, you might want to read the casebook. We are using Contracts, a Contemporary Approach by Kuhns, Chomsky, Martin, and Schlitz. And today we're on page 560 to 564 in the casebook. If you haven't had a chance to pre-read, you might want to take a look at those materials and tune back in. But today is mostly a discussion about philosophy. I think I can do a lot in just a conversation. In prior lessons, we learned how courts interpret the reasonable objective meaning of contracts using what we call the canons of construction. In this video, we're going to go a bit deeper. We're going to talk about what is essentially a philosophy of language question and a jurisprudential philosophy, and distinguishing a subjective and an objective approach. Applications of the canons of construction is predicated on an assumption that words in a contract can be understood objectively. But is meaning truly objective? Or do judges really incorporate some amount of subjectivity into their reading of contracts? I already mentioned how Justice Holmes and others have proposed an objective theory of contract interpretation. But the Restatement Second of Contracts seems to take a different position. Restatement Section of Contracts, Section 201, Comment B says, and I quote, "The meaning of words and other symbols commonly depends on their context. So, to interpret the words in a contract, a court seeks to put itself in the position the parties occupied at the time the contract was made." Seems to me that opens the door to a subjective approach to contract interpretation. An illustration from the Restatement case highlights the difficulty with a purely objective theory of contract interpretation as well. Restatement, as you might remember, is the case about the meaning of the word chicken. In Restatement, Judge Friendly purports to take a wholly objective approach. He quotes Justice Holmes and writes, "The making of a contract depends not on the agreement of two minds and one intention, but on the agreement of two external signs, not on having the parties meant the same thing, but on having said the same thing." Well, that sure sounds like an objective standard, and that quote is a good statement of the objective approach. But did Judge Friendly really follow his own advice? Well, in that case, he goes on to consider what each party thought chickens meant. And he eventually concluded that the buyer and the seller did not share the same subjective meaning. So we see there's at least a hint of subjectivity involved in contract interpretation. A court would probably not insist on an objectively reasonable interpretation of a term that the parties clearly did not intend or believe. Likewise, if parties both impute the same but unusual meaning to a contract term, why would a court impose a common dictionary meaning upon the term that the parties intended differently? This is why I listed reasonable common sense and preliminary negotiations as the third and fourth priorities in contract interpretation. Reasonable common sense and preliminary negotiations help courts decide when, whether, and which canons to use. These subjective perspectives, therefore, can have a big impact on so-called objective meaning. Others, of course, will disagree. But let's return to the Restatement, in part because it seems to accord with my philosophy, which says that where the parties have attached the same meaning to a promise or agreement or a term thereof, it is interpreted in accordance with that meaning. This seems to mean that a common subjective meaning is given priority over an objectively reasonable interpretation. But according to the Restatement, where the parties' subjective meanings do not agree, which prevails? Well, if parties have two different subjective meanings, the one that is more in line with an objectively reasonable interpretation should prevail. In other words, where parties do not share a common subjective meaning, we prefer the party's meaning which accords with an objective understanding. And then what about the rare case where the parties do not share a subjective meaning and neither party's own subjective meaning accords with an objective meaning. Or, for that matter, where both parties' subjective meaning each accords with a different objective meaning, neither of which is more reasonable than the other. How do we decide among the two? Well, where the parties did not have a mutual understanding about a subjective meaning, and neither party's own meaning better accords with objective meaning, there may actually be no agreement at all. Do you remember the case of Raffles v. Wickelhaus? This is the popularly known as Two Ships Peerless. In that case, the contract was to ship cotton to arrive ex-Peerless from Bombay. The problem is there were actually two ships named Peerless that sailed from Bombay. The first was to depart in October, the second to depart in December. The price of cotton and the need for cotton changes in the meantime. Which ship, the December Peerless or the October Peerless, is referenced by this contract? The parties clearly did not have a mutual understanding about which ships transport the cotton. One thought October, one thought December, and neither the October Peerless nor the December Peerless was more objectively reasonable. Therefore, the parties did not actually manifest mutual intent, and they did not really form a contract at all. Thus, we see the absence of common, subjective, and objective meaning can defeat a contract. Although, in some cases, a court has an alternative. They can construe the contract against the drafter, giving the non-drafter's meaning to the term at issue. It's in Latin, contra preferentum, construction against the drafter. Setting that aside for a moment, let's ask, is this process a question of law or a question of fact? And here again we can look at the restatement for a resolution. Restatement section 212 shows the fact-law question does not have a simple answer. To the extent that decisions about meaning turn on evaluations of credibility or require a choice among reasonable inferences to be drawn from extrinsic evidence, they are indeed questions of fact. But if meaning is to be derived from the words themselves, especially in a contract document that is written, courts have often treated that process as a matter of law. So we might actually think that the canons of construction are tantamount to rules of law. Restatement section 212, comment D, has a bit more to say. Quote, general usage as to the meaning of the words in the English language is commonly a proper subject for judicial notice without the aid of extrinsic evidence to the writing. Historically, moreover, partly because of the fact that most jurors were often illiterate, questions of interpretation of writings were often treated as questions of law, in the sense they are decided by the trial judge and not by the illiterate jury. Likewise, since an appellate court is commonly in a good position to decide such questions as the trial judge is, a contract is no more or less of a cold record on trial or on appellate review. These have been treated as matters of law for appellate purposes. Case law is useful to illustrate this point, so let's turn to the case of Klapp versus United Insurance Group. In this case, a man named Klapp sold insurance for UIG, and he received commission payments in return for these sales. The commission payments were defined in both the agent's agreement and another document, the agent's manual. But these documents seem to say different things. The agent's agreement indicated the commissions would be paid to a retiree on a scale, but starting with 2 years of service. The agent's manual required a retiring agent must be at least 65 years old and have 10 years of experience. Well, our friend Klapp, he worked for 7 years and then retired, and UIG refused to pay him, saying that, did you read the manual? And he said, did you read the agreement? What's the result here where the documents disagree? The trial court found, as a matter of law, that the contract was ambiguous. It said two different things, it's therefore ambiguous. And then it left it to the jury to decide which of these were more persuasive based on other evidence. The jury, being the fact finder, found in favor of Klapp. Well, the insurance company appealed, and the appellate court found the contract was unambiguous. As a matter of law, the appellate court said the trial court was wrong. The document was unambiguous, and it reversed in favor of the insurance company. The Supreme Court reversed again, the Supreme Court concluded that the language was, as a matter of law, ambiguous, and therefore its interpretation is a matter of fact, based on credible evidence, since the jury found that the meaning supported Klapp's interpretation. The appellate court should not disturb that finding of fact by a jury, unless it's clearly erroneous. Matters of law are reviewed de novo. This is not just a difference in application. These courts express different jurisprudential philosophies. The trial court and the majority of the Supreme Court took a subjective view of contract interpretation. These judges seem to believe that the point of contract interpretation is to understand the intent of the parties. And the best way to do that is to consider what do the parties say and do and think. Which means we need to hear their testimony. Extrinsic evidence is admissible to understand that intent. The appellate court and the concurrence on the Supreme Court seem to believe that reading the words on the page in a vacuum first furthers important policies. This is the objective view of contracts. Can we read it in a vacuum and understand it? If we can, let's move on. Why? It incentivizes drafters to use clear language. It provides speedier and easier trials. It promotes reliance on language and contract. Which is better, the subjective or the objective approach? That's up to you to decide. To recap, contract interpretation, at least with regard to a written agreement, begins with a careful study of the words written within its four corners on the page. We first look at the express terms, the intrinsic evidence, and we do give great weight to these terms, at least where they're clear and unambiguous on their face. That said, there are outlier cases, last lesson we saw Nana Cooley, that ignores the plain meaning when intrinsic evidence is so compelling. We can then apply the 13 canons of construction, effectively in a vacuum, to objectively understand the meaning of the written terms. Or can we? Some scholars are skeptical about whether a purely objective approach is feasible. The restatement seems to allow for, maybe require, a more subjective approach, whereby courts will hear evidence from the parties about what they actually thought the terms meant. In the next lesson, we will look at how extrinsic evidence, including course of performance, course of dealing, and usage of trade, and in some cases preliminary negotiations, can be used in contract interpretation. We will ask two fundamental questions. First, when can extrinsic evidence be used to show that a written contract is ambiguous? That's the story of latent ambiguity. And second, when can extrinsic evidence be used to modify or add a term in a written contract? And that's the story of parole evidence. In answer to the first question, when can extrinsic evidence be used to show that a written contract is ambiguous? This is related to our discussion of the canons of construction, in that extrinsic evidence might show we need to use additional canons beyond the simple dictionary meaning, or even that we should ignore the canons because the party's intention is not reasonable. In answer to the second question, when can extrinsic evidence be used to modify or add a term to a written contract? Well, that's called the parole evidence rule, and I have a two-part series for you on that one. So, up next, we'll learn about patent ambiguity and latent ambiguity, and we will see how the objective and subjective theories of contract interpretation apply differently to these different types of ambiguity. Thanks for tuning in. I'll see you next time.